Welcome to the People's Law School. My name is John Brinkley, and I'm a member of the Alabama Association for Justice. We're going to be listening to Lonzo Robinson. He's a local lawyer here from Huntsville, and I will tell you quite frankly that besides the judges, Lonzo is one of the lawyers who's at the courthouse the very most. Anytime you go up to the courthouse, you will see Lonzo. Sometimes you'll see him running from his office to his car and back into the courthouse, but that's about the extent of his absence from the courthouse on a regular basis. This guy tries cases. He's going to tell you a little bit about that. But leading up to his time before he was a lawyer, he was a member of the United States Navy where he was an enlisted man. He would tell you that means he worked for a living. In 1994, he graduated from the University of Alabama in Birmingham. 3 years later, he graduated from the University of Alabama's Law School. Thereafter, he worked for Circuit Judge James P. Smith. From there, he went on to be an assistant district attorney for Tim Morgan at the time. And then he went on to work here for the city of Huntsville, where he was an assistant city prosecutor. It's interesting to know that he has been on both sides of the fence. He's done the white hat and the black hat. Presently, I think he has been an attorney for the Department of Human Resources, and he's also been a substitute judge at the city of Huntsville for over a decade. Presently, he's also an administrative hearing officer here for the city of Huntsville, which is to say that he reviews reports that come in for those who work for the city of Huntsville. He's also been in private practice for over 12 years, initially with Daniels and Robinson, and now he's a solo practitioner. His practice is a general practice with a lot of emphasis on criminal law and in the domestic arena. He has tried everything from a speeding ticket to a capital murder case and everything there in between. At one time he was flattered by our local bar when he was elected the secretary for the Huntsville-Madison County Bar Association, and he has also been a member of the grievance committee. If someone makes a complaint about a local lawyer, our local bar entertains such a report, and Lonzo was one of those who was well thought of enough to listen to these complaints, and there are a lot of them, you can imagine, and he determines whether or not there's any real traction or any heat to what it is that the person has discussed. He has been married for 20 years to his wife Iris, and they have one son, Brandon, and he's 13 years old, and from what I understand he likes to argue a little bit, and that doesn't necessarily mean he's going to be a lawyer. However, Lonzo is going to talk to you a little bit about some of the things that Brandon's been arguing with him about as a teenager. It's my pleasure to introduce Lonzo Robinson. You're going to learn a lot from this guy. Sometimes I have to lean on him when I need an answer to something on the fly, and he's standing, as I told you, at the courthouse, ready to go. Lonzo is someone that you can go to, you can trust, and you can depend on.
Good evening. So I listen to the Brinkleys, and they come up and they say all these wonderful things about me, and a couple of them we probably need to correct. John Brinkley gets in here and he says I'm at the courthouse all the time. And it's not really correct, but make sure you're clear on something. The more time an attorney spends at the courthouse, the less money he has. The lawyers like John and Alan, you're going to see them over in their office and they're making the big money, and I'm just struggling to get by. You know, it's a daily day grind. And Alan, he mentioned that I got on his nerves recently, that we had a little trouble. And sometimes that's good. It reminded me last week, I'm at the courthouse, walking from my car, as John said, and as I'm walking, a truck pulls up. And the guy starts to blow his horn. Robinson, you so-and-so, you took custody from me and gave it to my wife. I hate you. And to me, I'm telling you, that's the biggest flattery I can get. When people come up to you and they're mad because you did a good job for the other side. If you do your job ethically and you do it above board and they're mad, then you've done a good job. But like I said, I wanted to thank the Brinkleys and thank the municipal court for letting us have this wonderful program in this courtroom. I've gone to a number of municipal courthouses, and I can tell you that the Huntsville-Madison County Bar, or the Huntsville Municipal Court is probably one of the best ones we've got statewide. In fact, ironically, I spent the better part of this weekend in this very courtroom. My son, as you were told, I've got a 13-year-old child, and he is in a group that is learning about the American judicial system. So the 7th and 8th graders, they came up here, and they were attorneys. They had a little plot that they had to do. They were the attorneys, they were the plaintiffs, the defendants, judge, bailiff, the full nine. Now, we ran out of big kids by the time we went to the jury, so the jury was a little bit younger. So you got all these kids, and they're putting on the trial, and I was the coach. I tried to help them along, and of course, my child would choose to be an attorney, and he's studying for it, and he's intense. I mean, he was intense with it, and I could tell. I could tell he was more intense than me, and you can see he will be a better attorney than I could ever be. So he gets up there, and he's cross-examining this guy, and I'm waiting on that, you can't handle the truth moment, and they go through, and they lose. And instead of him seeing him get disappointed and upset, he's mad. You know, you look in his eyes because he knows they should have won. I walk up to him and try and do the little father knows best, Fred McMurray thing. Son, it's okay. What'd you learn? And he balls up his fist and he says, Dad, I learned that you never let the other attorney put his brothers and sisters on the jury. And I said, son, you're right. But it was an important lesson, because what we do as criminal defense attorneys is we're dealing with people's liberty. We're dealing with your liberty, your ability to come and go as you please. And when you're doing that, I think you do need to ensure that you dot your I's and you cross your T's and you make sure that everything is perfect. You have to. It is your duty as an advocate for this person to ensure that they receive the best defense that they can receive. So what we're going to do today is just talk about a little bit of the nuts and bolts of the criminal system here in the state of Alabama. Now, at any time, if anyone gets a question, I don't think we're going to wait to the end. If you get a question, you just stop me. If my head's down, if I'm looking at a note, just yell, hey, Robinson, I got a question. And I promise you, I'll look up and we'll try our best to answer that question. Well, like I said, we want to talk about really kind of the nuts and bolts. But first of all, I think we need to kind of differentiate between criminal and civil. And sometimes there can be a little bit of confusion. Those are the two big categories in American jurisprudence, criminal and civil. As a general rule, when you're talking about criminal law, you are talking about liberty, as opposed to civil law, in which you're talking about property. In a civil case, you are suing someone for money, to be compensated for some wrong, some perceived wrong that you think has been perpetrated upon you. In a criminal case, you are being sued by a governmental entity for breaking the laws of the state or the county or the city or wherever you are. And that's a major difference. Remember, the civil actions have to be brought by people. And I know sometimes people say, well, corporations bring civil suits. Well, corporations are considered people. I know we may not, but in the law, corporations, politicians, and lawyers are all considered people. But in a criminal case, it's the government. That's why you see the case is styled, or the name of a case. It's going to be State of Alabama versus Lonzo Robinson. City of Huntsville versus Lonzo Robinson. The federal government versus Lonzo Robinson. Because you as a citizen cannot sue someone criminally. You can bring a criminal action. There's a process for you to bring it, but you cannot, it is not your case. It is a case which is brought by a district attorney or a municipal attorney. Another difference is the burden of proof. In a criminal case, because it's liberty as opposed to a property, there is a higher burden of proof. You've heard the term beyond a reasonable doubt. That is the burden in a criminal case. Whereas in a civil case, it is what's called a preponderance of the evidence. Preponderance of the evidence sounds bigger, and in fact, I've tried civil cases, and you'll go and you tell the jury, ladies and gentlemen of the jury, in that criminal case, all they have to prove is beyond a reasonable doubt. We have to prove a preponderance of the evidence, and you say it like that, and you try, but it's really kind of a scale. If you feel this side is a little bit better, or that side is a little bit better, then that's usually the side you go with, because once again, it's a lower burden because it's property. In criminal, it's beyond a reasonable doubt, and I am not going to try and define beyond a reasonable doubt. Every case we have, there is a different definition of beyond a reasonable doubt. Usually it's going to be something like it's a doubt for which a reasonable person can articulate that is reasonable. You know, you keep the problem with the definition is reasonable is thrown in there. A reasonable doubt. It's a doubt that's reasonable. You know, you can't, it makes it confusing, and I'm not going to try and define that, and I think that may be a little bit beyond the scope of what we're doing now to just try and go that far. Keep in mind that you have years of law school with criminal cases. We're going to try and squeeze an hour into this one. But beyond criminal and civil, once you get to the criminal case, because that's what we're talking about today, you have misdemeanors and felonies. And there is a difference between misdemeanors and felonies. The first and most obvious difference is the range of punishment. In a misdemeanor, by definition, a misdemeanor is a case in which you cannot receive punishment of more than a year. 0 to a year punishment, statutorily, is a misdemeanor. A year and a day and above are felonies. There are, with felonies, there are some other consequences as well. You get a felony, you may lose your voting rights. You get a felony, there may be restrictions on your employment. You get a felony, you may have professional licenses revoked, or you may not be able to get a professional license. And it's weird, I was looking up some of the statutes for this, and it was surprising. Some of the professional licenses that you cannot get were surprising to me. I understood, you know, the doctor, the lawyer, the psychologist, but then I started looking and it said auctioneer. It's like, wow, you can't be an auctioneer. Then I looked and said massage therapist. You can't be a massage therapist. Then I looked and I saw cosmetologist. You can't be a licensed cosmetologist if you have a felony. And no, these are jobs that may not have a professional degree in that you've gone to law school for 3 years. These are jobs that people can usually go and get, and they may not realize that. So I guess the key is to remember, if you want to be a cosmetologist, you may want to leave the marijuana alone, because you may not be able to get that job. But with misdemeanors, we're going to stick with misdemeanors for just a second. There are 2 different types of courts that hear misdemeanors: municipal courts and district courts. The district courts, well, let's look at it this way. The sheriff of Madison County has jurisdiction throughout the entirety of Madison County to make arrests. So anywhere in Madison County, if a deputy sees a crime happening, or if a deputy is called, he can make an arrest. Municipalities, some of the larger municipalities, have their own police and they have their own municipal court. We are here in the city of Huntsville Municipal Court right now. The city officers, when they make arrests, they have court here in the city of Huntsville. What's strange about it is there's a difference in the punishment. They're all misdemeanors. They're all crimes. And you can't explain the difference, but if a deputy arrests you, you go to district court. That's a state court, the District Court of Madison County. In the District Court of Madison County, a misdemeanor has a range of punishment of up to a year in jail and a fine of up to $6,000. So if you, well, not y'all, but some other citizens of Madison County, if y'all went and committed a theft in bulk, and you were taken by the sheriff's department over to district court, you could have a year in jail, $6,000 fine. You commit the same offense, and the management at Belk decides we're going to call the police department. Instead of a year, it's 180 days. Instead of $6,000, it's $500. I have no idea the difference. Same person commits the offense, same place, different person arrests you, and you have a different a punishment that can be given out to you. Keep in mind, just to really kind of explain misdemeanors, these are the lower crimes. I think a lot of times when people hear about misdemeanors, they think about shoplifting, any theft under $500 that doesn't have a weapon used is a misdemeanor theft. You think about harassment, when someone attempts to annoy you without justification. My very first case to try in the district attorney's office, I was there for about a week. And this attorney, he's an attorney of prominence here in Madison County now, so I won't say his name, but he was assigned to mentor me and to tutor me and to show me how to do it the right way. So we go into court for the very first time, and there's this case. I found out later it's been continued for 4 months. He's known the new guy's coming, so I'm not going to try this. The new guy's coming. So he continues the case. I go in there, and I'm trying a case against Bruce Gardner, who's one of the best attorneys in town. And I'm fresh, I mean really wet behind the ears. And we get there, and we got these guys out in the county. And they're like the Hatfields and the McCoys. They've gone and they've gotten because they hate each other so much, one of the neighbors has cut hefty bags and laid them over the fence so that the other neighbor could not peer into his yard. The second neighbor is telling him to stop. And they can't see each other. But one of them says, well, I know he poked me through that fence. I couldn't see him, but I know it's him. And that's the case I went to try. The very first case. And then, but the strange part is, after they left us, they went to TV. They went to Judge Joe Brown, and they tried the very same case. The judge found the same way, which was against us. But in any event, misdemeanors are generally going to be a little bit smaller. They're not going to be as serious. They are not going to have as much either property damage or personal damage to the people. But although the misdemeanors are tried in the district court or the municipal court by a judge and not a jury, Alabama has set up a process. It's called an appeal de novo. If you lose in district court, if you lose in municipal court, you can ask for a completely new trial. It's like the first trial never happened, and that's up in circuit court. That's a jury trial, the same place where the felonies go to be tried. It's a jury trial. You get to have it, 12 of your peers come and hear that case. Now, I can tell you from experience, there is nothing a circuit court judge who has the robberies, rapes, and murders on his docket, there's nothing that he's going to hate worse than seeing somebody with a speeding ticket or somebody with a failure to yield come up and say that they want to waste the whole day with a jury trial. But that's your right. You have a right. Anything that happens here in municipal court, anything that happens in district court, you can appeal up to circuit court, ask for a trial de novo and a jury trial. And many times you will get a much better deal because the prosecutor, honestly, a case, and I'm not saying it's trivial because every case is important to someone, but the resources extended to try a speeding ticket to a jury usually are just not worth it. After you get through with the felonies, with the misdemeanors, you have felonies. Felonies, those are the big cases, by and large. Those are the cases that when juries come, they want to hear. There are 3 types of felonies in Alabama. Every state does it different. Every state gets to decide how to divide up their felonies, their courts, even their misdemeanors. They get to do it their own way. There's no one watching over them. The federal government doesn't say, you have to do it this way. Alabama has said that we will make ours A, B, and C. C felony, clearly it's going to be the lowest felony. With a C felony, the range of punishment is 1 year and a day to 10 years. Remember when we talked about misdemeanors and felonies, I said that by definition, anything above 1 year and a day is a felony. So the lowest grade felony in the state is a Class C, 1 year and a day to 10 years. And keep in mind, that time can be suspended and you placed on probation. That's one option. And by that I mean, let's say you have a Class C felony and the judge sentences you to 2 years. The judge can say, I am sentencing you to 2 years, but we are going to suspend that time. And instead of you going to jail, you will get to remain outside of jail. You will report once a month to a probation officer under conditions of probation. There are usually a number of conditions, the chief being that you can't commit a new offense. And the thing that gets most people, unfortunately, revoked is drug, they are drug screened and they test positive for some illegal substance. But as I said, 1 year and a day to 10, the first option is they can suspend the time and place you on probation. So if you have what's called 2 suspended 3, that means that there's 2 years over your head, but it's over your head for a period of 3 years. You report for 36 months to probation. After that 36 months, you are released and your probationary status is completed. If during that 3-year period of time you do something to get revoked, your probationary status will be revoked. If you catch a new offense, you commit a new offense. If you test positive on a drug screen, you do one of those things, the judge can come and take away your probationary status and send you to jail for the 2 years that was over your head. So that's option 1. Option 2 is the judge can sentence you to jail time. The judge can say, I sentence you to 2 years in the state penitentiary, and the 2 years is just an arbitrary number that I'm throwing out. I sentence you to 2 years in the state penitentiary, and you are to go now. You're sentenced to 2 years. We're going to talk a little bit more in a few minutes about what 2 years means and things that take that time down. But the third option is a split sentence. Alabama has what we call the Alabama Split Sentence Act, and that means you get a little bit of both. The judge can say you are sentenced to 2 years, but you will serve 6 months in jail, and after that 6 months you do in jail, I will place you on probation. Usually you see that, the judges want to give someone a taste of what jail is like. It may be someone that they think can be rehabilitated, and they may do that. It is, by statute, it is not to be used as punitive in nature, the split sentence, but in practice it is. I tried a case here in Madison County, and the young man was charged with murder, and he was charged with possession of marijuana in the first degree. Now, the murder we got a not guilty off of, which, was great. You got a not guilty on a murder. The possession of marijuana, which was possession of marijuana first, it's a Class C felony, like we were just talking about. The judge gave him 10 years. Now, why do you think he got 10 years? Not guilty on the murder, guilty on the marijuana. 10 years, and then he split that time to have him serve 3 years in the jail. Now, with a split sentence, you have to do the time day for day. We're going to talk, as I said, in a few minutes about how they compute time, but to do that is about as punitive as it can get, but that's just the realities of what happens. The law was not designed to be punitive, but it is. Yes, sir.
You keep using drug examples if somebody's on probation. What happens if somebody's on probation and they get a speeding ticket or a DUI?
All right. Now, see, those are two different things, the speeding and the DUI. Oh, I'm sorry. Let me repeat the question. Your question was, I think, what happens to someone on probation if they get convicted of or charged with an offense other than a drug-related offense. Something specifically, speeding or DUI was the question. And I would say that speeding and DUI, first of all, are going to be a little bit different. Speeding is viewed more criminally than, I'm sorry, let me reverse that. The DUI is viewed more criminally than the speeding case. You can be revoked from probation, and I've seen judges threaten to revoke people from probation more over a driving while suspended or driving while revoked than a speeding. I have never seen a speeding ticket get someone revoked. However, a DUI is something different. A DUI, that means that you have intentionally gone somewhere and imbued more alcohol than the legal limit, either a .08 or above, or you have drank enough alcohol to where you cannot safely operate a motor vehicle. That is an intentional act, and the courts will revoke your probationary status for that. At least in Madison County, they will. The Madison County judges are tough. I would call them fair, but they're tough, and if you get a DUI, you need to be talking to your probation officer, asking them for something. But I would say, too, that revocation is not the only, that's not the only punishment. It's possible that they could send them to treatment. You know, they could go to a DUI class, inpatient, outpatient. There are other options short of revoking, especially if someone has a big sentence. The jails are packed, and I don't think currently it is not fiscally responsible to send people to jail over minor offenses. Yes, sir.
If I recall correctly, under the military law, that if somebody is found guilty of something and they appeal it, that the appellate court can still find the person guilty, if you will, but cannot exceed what the lower court had imposed. Is that true in the civilian world?
Okay. The question was, and stop me if I get it wrong, in a military action,
That's what I understand, as I recall.
to the best of your knowledge, in a military action, if someone appeals a case, they cannot get a punishment that is more severe than what they received at the lower level. Now, see, there are two different types of appeal. We spoke a few minutes ago about a misdemeanor appeal. A misdemeanor appeal is a trial de novo. If you come right here and you try a case before this judge, and that judge gives you probation, 30 days, suspended for a year. When you appeal to circuit court for a jury trial, with that trial de novo, it's a completely new trial, and whatever happened down in municipal court, district court, wherever the lower court was, it did not occur. So you can get anything within that range of punishment. In municipal court, it's up to 180 days. In district court, it's up to a year. Now there are some exceptions to that municipal court range. You know, DUI, that's an exception. You can get a much stiffer punishment. But if your appeal is an appeal from a jury trial, that's a different type of appeal. An appeal from a jury trial, whether it be criminal or civil, goes to the Court of Appeals. The Court of Appeals does not retry the case. What they do is they look at the transcript. They look at the evidence that was presented. They look at the objections that were made and the decisions of the judge. And you, as the appellant, have to convince them that the judge or the jury, usually it's the judge, has done something outside of the scope of his authority. So in that, you cannot get a stiffer punishment. You can only have the case affirmed or remanded back to be changed. Did I answer that question appropriately?
So if it's remanded back, then it's not double jeopardy.
Well, if it's an appeal to the Court of Appeals, it's just, well, it's more of affirmed. It's affirmed or it's not affirmed. If it's affirmed, your sentence goes on, and if it's not, if they send it back, then you may have to have a new trial or do whatever was determined to be wrong may have to be corrected. I think what we were talking about a second ago, we were talking about A, B, and C. We talked about the C, the range of punishment for a C. A B punishment, the punishment for a B is a little bit more. Whereas a C is a year and a day to 10, a B is 2 to 20. That means 2 years is the minimum you can get for a Class B felony. 20 years is the maximum you can get. An A felony has an even stiffer range of punishment. An A felony, as a general rule, is 10 to 99 or life. That's how they say it, 99 or life. And I don't know why they say it that way, because I honestly think the way it's calculated, 99 years is considered to be more than life. But it's 10 to 99 is an A. There are, with the range of punishment with each one of these, there are what we call sentencing enhancements. What people normally think about is you hear folks talk about 3 strikes rule. 3 strikes and you're out. Especially a lot of baseball fans, you hear that, and I think you hear people talk about that in federal court. That's not really the way the Alabama system is set up when it comes to habitual offenders, and that's what we call it. We have the Habitual Offender Act. So let's say you have a C felony. What we just talked about was that in a C felony, your range of punishment is a year and a day to 10. If you have a C felony with 1 prior felony offense, then instead of a year and a day to 10, it's 2 to 20. If you have a C felony and you have 2 prior felony offenses, it becomes 10 to 99. 3, 15 to 99. It goes up. So what the statute does is it looks at the nature of your offense, and it looks at your prior criminal history. And there are charts and graphs, and it tells what should happen. And every lawyer has to be familiar with that, especially new lawyers or lawyers who are just starting out. We talked a second ago about my first trial. Well, it was also my first criminal defense trial. And I left the city attorney's office on a Friday. And I went over with my partner at the time, Lee Daniel, on a Monday. I had previously been a clerk for Judge Jim Smith, and he appointed me to a couple of cases. So Tuesday, I get appointed a case, and I'm happy. I'm looking at it. Robbery 1. My client is alleged to have gotten a gun, gone through and robbed some people and did stuff. Very first case I had. They don't start me with anything simple. They start me with a robbery. So it's set 3 days later for trial. I go in and I just know the judge is going to continue it, and I come in with my button. Well, Your Honor, I was just appointed on this a couple of days ago, and we need our continuance so I can meet with my client and get prepared. And the judge goes, well, it's a 2-week docket. We won't start your trial until next Monday. So I get in there, and I think, oh, my goodness. And it doesn't hurt that my client's scared, man. I go visit him in the little room they used to have over at the jail, and the guy was like intimidating and imposing. And my last lawyer messed me over, and now you're in here, and you're a new lawyer, and you can't do nothing for me. And I'm sitting in there, and I'm scared, and I don't know what to do. So I do all this work, and I'm prepared, and I go in there, and we've talked about the range of punishment, and I sit down, and we come to the trial day. We go up there on the trial day. And then that's when somebody tells me he has 3 prior felonies. So instead of him looking at a Class A felony, 15 to 99, he's looking at life or life without. Huge difference. Instead of 10 being his minimum, it's life. And here I am. I didn't even know. Luckily, we ended up getting a not guilty on that one, and it was a good verdict, but it's scary. That's one of the things a lawyer has to know. And with that week's time, I didn't discover what his range of punishment was. So I probably informed him wrong, but we won the case. So it's a mistake of a new lawyer, and it happens. But you have to know that each time your client has a prior felony, and the DA's office will assert them, and they had asserted the priors in this case. They had sent notice to the previous attorney, but of course, I wasn't the previous attorney. And I'm getting caught up in all these things, and we got it, and it had a good result. But once again, this was one of those cases where he got off on this huge part, and he had like a joint or something with him, I think, and this guy ended up getting a year in jail for the joint when he was looking for the life and looking at life, and he filed a bar complaint saying that I was ineffective. And that, you know, I actually kind of framed that. You get a case, and you've been on it for a week, and you get a guy off of attempted murder where he's looking at life without, and he hasn't spent a year in jail when he's already done 8 months. It was, I considered it a win, and the appellate court tended to agree with me. But that's one of the enhancement provisions. There are others. If you commit a felony when you use a firearm, the law does not like firearms to be used in cases. I understand we like our guns, but we don't like our guns when they're used to commit a felony. We don't like them when they're used to commit a robbery. We don't like them when they're used in the commission of a burglary, a rape, a murder, whatever. You know, if you commit a Class A felony while you use a weapon, your minimum punishment jumps up to 20 years. And that's just by statute. That's one of the things we do. If you are a drug seller and you sell around the school, we don't like that either. You want to sell drugs? That's bad enough. But you can't sell them around the school, and you can't sell them to kids. You sell drugs to kids, you're going to get hit harder by statute. You sell drugs within a certain distance of a school, you're going to get harder. And honestly, though, when you think about that, there are not a whole lot of places you can go in Madison County that aren't far from schools. There are a lot of schools around here. You also have increased punishment for certain offenses like trafficking in drugs. You have drug sales, but then if you have a drug sale with a tremendous amount of drugs, that is what we call trafficking. You get your trafficking, you have a minimum mandatory of 3 years on the baseline. That means there are 3 years you got to serve no matter what. Although it may be 10 and above as your punishment, there's 3 years you have to serve, day for day, without any probation, parole, early getting out, any of that stuff. And one of the other big sentencing enhancement provisions are for sexual predators. You know, we talk about things we don't like. That's one of the things we really don't like. The law has come up with some very steep enhancements for people who commit sexual offenses to children under 12. We're going to talk in a few minutes about things that take away from your sentence. You don't get any of those. Any of the things we're about to talk about, you get none of those if you commit a sexual offense to someone 12 years and under. That minimum sentence on a Class B, instead of being 2 to 20, it is 10 years is the minimum. And that's 10 years to serve. Whereas, you know, you give someone a sentence of 10 years normally. I keep telling these stories. Another time, just talking about that 10 years, it made me think about one. Another time, right when I was fresh as a criminal defense attorney, I had a client, and he was sentenced to 10 years. And this was in the summer, maybe July. Christmas, I'm shopping, and I see him. He's walking around. He just got sentenced to 10 years, and he's walking around. And I go, oh my, do I need to contact the bar? And can I say I saw him? He's escaped. This guy's out. No, he hadn't escaped. One of the things we're going to talk about in a few minutes is they have things to let you get out early. And, you know, that's another thing as an attorney you have to make sure you are fully aware of and you fully know. And the first of those is what we call good time credits. There is a statute in Alabama that says for time you spend in the penitentiary where you're good and you don't get in trouble, they will give you credit on your sentence. You know, like it. Some of it can be pretty high. You know, I was looking at the chart. You know, a year. If you spend a year, you might get 6 months credit on your sentence for not getting in trouble. I mean, think about that. So that's one of the reasons in Alabama we don't have what's called truth in sentencing, because when a person is sentenced, we don't know what they're going to get. I always tell my clients, if you're sentenced to 10 years, you need to be prepared to do 10 years. But folks get out really early sometimes. In addition to good time credit, you have parole. Parole is different from probation. We briefly touched on probation a few minutes ago. With probation, that is normally done either as a part of a plea agreement or it is done by the judge, but it's done at the trial court level. You get some time, that time is suspended, you're placed on probation, you report monthly to a probation officer. You don't go to jail. With parole, while you are in the Department of Corrections, they have a board. It's called a parole board, and it is strictly up to them. The parole board can decide to let you go home even though you are still considered to be in the Department of Corrections. You are under the authority of the Department of Corrections, but you're out. Now, with parole, it's a little bit easier to revoke you even than probation, because you are under almost a complete authority of that parole board and that parole officer. But some aspects of it are similar. You're going to report to a parole officer. You can't commit any new offenses. You cannot be around people of ill repute. You cannot commit injurious activities, is I think maybe the language they use. But parole gets you out earlier. We also have something called community corrections. Community corrections is actually the newest thing. Community corrections, it's sort of like ankle bracelet. You are still in jail, but your jail is your mama's house. You get that ankle bracelet on, and you can't leave within a certain footage of that house. If you do, an alarm goes off, and your community corrections officer is made aware that you have. Now, to me, if I'm in jail, I've got some big sentence over my head, and I'm in jail and I'm eating this horrible food, and I'm sleeping worried about somebody beating me or whatever, and I can go home, stay in my mama's house or my wife's house or my girlfriend's house, whoever's house. I can stay in that house, and of course there are other restrictions, but the restriction is you can't leave. I'm taking that. My mom can come and cook for me. My girlfriend can come by. My kids can come by. Folks can see me. I can watch cable TV. I can get a bath. I can do all that. But what you see happen, and it's amazing. People leave. Oh, I had an argument with my girlfriend, so we had to go and I had to see what was wrong with her. You better call her on the phone, because you can't leave. This is even worse than being revoked from probation. This is worse than being revoked from parole. You are still in jail. The jail is the house. If you leave the house, the analogy is you leaving the penitentiary. When you leave the penitentiary, you get an escape charge. You leave the house, not only are you going back to jail, you're getting a new felony. Sentence enhancement, clearly you've got one felony already. So you're not going to get a good sentence. You're getting another sentence. It can run either, and I didn't even mention this, it can run either concurrently or consecutively. Because anytime you get more than one sentence, there are two ways they can run. Concurrently, they can run at the same time, or consecutive. You can get one sentence, and then when that's over, you can run you have to do the next. So people can get out a number of different ways. And one of the reasons they do that, like I said, financially, there is a worry that we are going to be taken over by the federal government with our prison system. It's overcrowded. It's underfunded. It's populated by a number of nonviolent offenders. The things that the things that we talked about as far as people getting out of jail, those by and large are for people who are nonviolent offenders, because we're looking at ways to get nonviolent offenders out of the jail so that there can be room for the people who commit murders, who commit robberies, who commit rapes, who commit the violent crimes where there are serious physical injury to people. So as I said, we're trying to get people out and get the jails a little bit less full. In fact, recently, the state of Alabama has come with a new way of sentencing people. We have sentencing guidelines, and the DAs work out a formula. And with this formula, more and more people are been given probation recently, and less people are going to jail. It takes a lot of the negotiation out of it, because a lot of, as the lawyers in here will tell you, a lot of lawyering is talking. It's building relationships and going to talk to people. In criminal cases, you better know your prosecutor. If I'm a defense attorney, I need to be able to call my prosecutor, and I need to be able to say, hey, look, there's something you need to look at in this case. And the prosecutor needs to be able to trust me. And that's something that's built from years of working together. He needs to know when I say A, it's A, and when I say B, it's B. Because the first time you as a defense attorney misrepresent anything to a judge or to a prosecutor, your reputation is gone, and you don't get that back. The only thing you've got is your reputation. So when you guys are out looking for an attorney, you know, so almost like when you look for a doctor, ask other attorneys if you know. Reputation is really, really key. In addition to what we talked about as far as people getting out early, there is, you also have what we call status offenses. Usually that's youthful offender. I don't think one of the things we're here to talk about today is juvenile court, but in summary, juvenile court is for children 18 and below. They have their own separate court, their own separate system, their own separate punishments, their own separate jails. Everything is completely different, and we could talk for hours about the juvenile system. But in sum, the law has said that if you are under 18, as a general rule, you do not have the capacity to form the intent to commit a crime. Thus, you are found to be a juvenile offender, a bad child. After you turn 18, but before you turn 21, you will be in state court. But you can make application to be treated and have some of the same benefits. It's called youthful offender. With a youthful offender, although you may give up your jury trial, you may have to have a bench trial, your range of punishment changes. The maximum you can get on a youthful offender is 3 years. Remember we talked about A, B, C? Maximum you can get is 3 years. In addition to that, and the most important thing, is your records are sealed. You get some guy, whether they're convicted or not, let's say you get some 19-year-old kid who is arrested for a robbery in the first degree. Whether he's convicted or not, you need to try and get him that youthful offender. And sometimes it's even more important if the case is dismissed. I've got one we're trying to get youthful offender on right now. The case was dismissed. It was dismissed by the grand jury, what they call a no bill. If we have time, we're going to talk about that. But he's 19 years old, and I'm going, well, Judge, I need the opportunity to apply him for youthful offender. His case was dismissed. He doesn't need every time he goes to apply for a job to have to explain, yes, I was arrested for this, but the charges were dropped. The youthful offender will keep out the arrest, and it will keep out the conviction. You will not. You are treated not as a delinquent child, a bad child, but as a youthful offender. Yes, sir.
Is it possible that somebody is 15 or 16 and be tried as an adult?
A person 15 or 16 can, in some instances, be tried as an adult. Usually, those are going to be the more violent offenses. There was a murder in one of the schools not long ago. I remember the victim's name, Todd Brown, but I cannot remember the offender's name. Okay. And he was charged as an adult. My recollection is he was somewhere around that age range. There are certain ways that a person under 18 can be charged as an adult. Usually it's either the nature of the offense or it's if he has committed so many offenses as a juvenile that they have made a determination that there's nothing further that the juvenile system can offer. The juvenile system is more about rehabilitation than punishment. Supposedly, the twin aims of the criminal justice system are rehabilitation and punishment. I think we're a little heavy on the punishment, but in juvenile, it's rehabilitation. So they have steps that they go through. The first time, you may be lectured and released. The second time, maybe boot camp. The third time, and it goes up. After a certain period of time, there's nothing further that can be offered. You have participated in every program, and they certify you. There's a process where they certify you as an adult. And so you will move up to adult court, and you'll be in big boy court dealing with the big boys, even though you're a little boy. And unfortunately, I mean, it really is sad to see sometimes. You see these little kids, and they are there, and they have to deal with, on a nightly basis, some big, scary folks.
The corollary to that is somebody who commits a crime as a child and is now 25.
Okay, let me repeat what you said. You said the corollary to that is someone who commits a crime
So
as a child.
Under 18, 17, 18, and
And
not
is
tried
not
until
adult.
they're...
Now, keep in mind, if you commit, and I haven't had that one come up, if you commit a crime as a juvenile, I'm not sure if you would be tried if you're arrested at 25 as an adult or a juvenile, but you've got to look at a number of things, including the statute of limitations. For most of those offenses, if it's that big of a time gap, I would think that there would be some type of a statute of limitations that would prevent the case from being brought. If it is serious enough where the statute of limitations wouldn't run, and usually that's going to be on something like a murder, then that's going to be a case where they could have been tried as an adult in any event. The other thing to keep in mind with that, sir, is a practical matter. If you wait years to try a case, the longer you wait to try a case, the better it is for the defense. You know, witnesses' memories are not quite as sharp as they were. People are not quite as sure. Witnesses may have moved to other areas. They may be deceased. There are a number of things that make trying cases later, I think, more difficult for prosecutors. I think we've talked a little bit about the status offenses. I was going to try and talk about the way the system went through. Honestly, I didn't think this would go as quick as it did. We're going really quick. So we're going to talk. I'm going to try and just shoot through this with the initiation of a case. Normally, they're initiated by a complaint. An officer with a felony usually brings the case. It is going to be brought by the officer because he has either witnessed it himself or he's an investigator and you have gone and made some complaint and it's been investigated and they've made a determination that most likely that this event did occur. You are then arrested. Within 72 hours, you need to have a bond hearing. You need to have a bond set. If you do not have a bond set within 72 hours, the law says you get a minimal bond or the minimum amount of bond in the range. At some point after that, usually you're going to have an attorney retained to represent you or appointed to represent you. One of the first things that attorney needs to ask for is a preliminary hearing. In Alabama, we have a preliminary hearing and the grand jury process. The preliminary hearing, in some states, it's called a probable cause hearing. It's the hearing where the state is required to show that there was probable cause for the arrest. What's bad about Alabama is if you can show that there was no probable cause, the prosecutor still has the discretion to go forward. Had a case. Lady's charged with theft, stealing from her brother, right? We come in and show the officer, look, we've got, here's what you said she did. Here is her power of attorney to represent him. Here's his medical stuff that shows she's doing it. She can have his power of attorney because he has mental illness. Here's the check you said that she wrote, that she used her name. It all showed that there was no crime committed. But the prosecutor said he still wanted to go forward. So this person who's been arrested, if we get the judge to say that there's no probable cause, the prosecutor can then go and arrest them again. And they have to go through the booking process again and bond out again and still have to try the case to a jury, which I think is just the most wrong thing in the world. And I really, really want to apologize to you. I had all these things I wanted to talk about. I didn't think I'd be up here but 15 minutes, and I ended up doing it for a full hour. I hope I was able to impart something on you, into you as far as the criminal justice system, and I really appreciate your time.
Thank you so much.
Yes, sir.